Vice Chair decides to leave. There we go. We have a number of bills that are on the consent file, which I will recite right now. So if you're here for items that are on consent, you don't have to stay unless you find this so fascinating and compelling, or you would otherwise have to go home and mow the lawn or do the dishes. But other than that, we have a number of items that are on proposed consent. I will list those. First, though, we've got two items, one item that was pulled at the author's request, which is file item 8, AB 1687 by Assemblymember Calderon, so we will not be hearing that today. And we do have an item that was originally set for consent but has been removed from consent because of late opposition, and that is file item 6, AB 1580 by Assemblymember Gatto, and that will be heard today. The following items, though, are on the proposed consent calendar. There are 18 of them, and they are file item 1, AB 54, Olson, file item 4, AB 885 by Lopez, item 7, AB 1684, Stone, item 9, AB 1702, Stone with amendments, item 10, AB 1709, Gallagher, item 11, AB 1722, Wagner, item 12, AB 1735, Waldron, item 13, AB 1750, Dodd, item 15, AB 1963, Calderon, item 18, AB 2128, Sajan, item 20, AB 2211, Linder, item 21, AB 2217, AB 2217, Hadley, item 22, AB 2258, Eggman, item 23, AB 2296, Lowe with amendments, item 24, AB 2416 by Wilk with amendments, item 29, AB 2761, Lowe with amendments, item 30, AB 2799 by Chow with amendments, and item 33, ACR 148 by Chow. I will not repeat those. I hope you caught them all, but those items are on the consent calendar, and where we're able to establish a quorum, they will be the consent items that we vote on. We are now going to start, as I mentioned, as a subcommittee, and we're going to start with file item 2, AB 488 by Assemblymember Gonzalez on employment discrimination. I would like, the way this committee operates, I think, most effectively is that we have two witnesses on each side, each able to testify for 2 minutes. Then we invite people to come up and give just simply their name, affiliation, and support or opposition to the bill. And then we generally, from that point, we'll have discussion. So if you would please, if there are several of you here to testify on behalf of a particular bill, there'll be 2 of you who will be given an opportunity to speak for 2 minutes each. With that, good afternoon. Thank you for being prompt. Assemblymember Gonzalez, file item 2.
Thank you, Chairwoman and Vice Chairman. AB 488 proposes to fix a glaring omission in the worker protections ensured by the California Fair Employment and Housing Act. FEHA currently exempts employees with disabilities working in sheltered workshops or rehabilitation centers under special minimum wage licenses from all of its prohibitions against discrimination and harassment, anti-retaliation measures, and reasonable accommodation provisions. This leaves these workers without the legal protections and recourse that have been deemed the civil rights of other employees, including unpaid interns and volunteers, should they find themselves in a case of discrimination or harassment based on factors like race, gender, or religion. These workers are indisputably employees under the California Labor Code and deserve workplace protections regardless of their work environment. I'll be taking clarifying amendments which eliminate the unnecessary inclusion of day programs, since these employees should have already been covered by FEHA. I'm also committed to continue to work with the opposition to further the amendments to address their concerns on the Senate floor. I received some amendments just a few hours ago, and we're not quite ready there, but we will continue to work with them on those amendments. With me today to speak in support is Bob Giavatti from the State Council on Developmental Disabilities, and Evelyn Abu-Hassan from Disability Rights California.
And before we have the testimony of your witnesses, there were, as I understand it, there were some amendments that were proposed that you are going to be taking, and in addition, talking with others on amendments that have yet to be discussed.
Yes, we'll be taking the committee's amendments that we worked with the committee on, and there are some additional amendments the opposition would like. We're going to continue to discuss those before we bring it to the Senate floor. It should get out today.
And if it does get out today and go, we'll reserve the right to return if there's some concern. Very good. Thank you very much. Appreciate your work on this. And our two witnesses, if you'd go ahead.
Evelyn Abu-Hassan with Disability Rights California. We are the co-sponsors of this bill. We're pleased to be working with Assemblymember Gonzalez on this issue. She framed it quite well, so I won't repeat what she has said. With me today is Andy Mudrick with our office to answer any technical questions the committee members may have. And with that, I'll just turn it over to Mr. Giavatti to have.
Yes, thank you, Madam Chair. Bob Giavatti with the State Council on Developmental Disabilities. I think the description in the analysis nailed it. The bill would eliminate the current exemption for any individual employed under a special license in a nonprofit shelter workshop or rehabilitation facility from the Fair Employment and Housing Act's FEHA definition of employee, thus protecting those individuals from any form of employment discrimination on the basis of race, religious creed, physical disability, mental disability, sex, age, and sexual orientation, among other things. It really is as simple as that. I have sympathy for the folks who may be in opposition to this bill. I respect them and work with them. But from the standpoint of the council, Madam Chair, we see the exemption from FEHA in sheltered workshops as, in essence, an anachronism within an anachronism. It's a remnant of a bygone era buried in a remnant of a bygone era. And for those reasons, we are co-sponsoring this bill and strongly support it. Thank you.
Thank you very much. Witnesses in support, other witnesses, if you'd step forward with your name, affiliation, and indicating your support of the bill.
Fine. Stay there.
Good afternoon.
Madam Chair, members, Robert Harris on behalf of SEIU California in strong support of this simple and necessary legislation.
Thank you.
Michael Young on behalf of the California Labor Federation, also here in support.
Thank you very much. Any other witnesses in support? Are there witnesses in opposition? Witnesses in opposition? Okay.
You can come back up if you have questions, okay?
Good afternoon, Madam Chair.
Good afternoon, sir.
Benjamin Palmer on behalf of the California Disability Services Association. We're currently in an oppose unless amended position due to concerns the bill would impose liability for non-discriminatory behavior authorized by existing law. We'd like to thank the sponsors for all the time they spent with us. I believe we are in agreement with the sponsors on amendments. The author appropriately is taking some time to review those amendments, but we are optimistic the bill is headed in a direction in which we can remove our opposition. But we cannot remove our opposition until the amendments are taken.
Thank you. Next witness in opposition.
This is Barry Giardini from California Disability Services Association with Ben. Just here for technical, if anybody has questions about how these programs operate.
For hand-holding purposes.
Ben doesn't need handle.
And to be clear, we support making it clear that all employees are entitled to protection from discrimination and harassment.
Other witnesses in opposition?
Madam Chair and members, Dwight Hanson on behalf of the Alliance. We're a statewide network of providers. We believe the Lanham Act is in fact a civil rights act, does in fact protect our clients from all of the protections that FEHA would otherwise offer. There are conflicts between protection of people with disabilities in FEHA and protection of people with disabilities in the Lanham Act. The problem is we, as employers of people with disabilities, must know about the person's disability, the severity of the disability, because we do more than just hire them. We support them, we counsel them, and we work with them on their disabilities. We aren't even sure how all these crossovers will conflict with each other, but we are very concerned that they will. And as a result, this bill, which offers no additional protection to people with disabilities, could in fact create havoc for those of us that are trying to support the lives of these folks.
Thank you very much. Any other witnesses in opposition? Bring it back to the members. I have a couple questions, and I'd like to ask the author of the bill or supporter some concern about the Lanham Act, that there is some potential overlap, but to the extent, do you agree that there is some concern where there might be differences? And if so, how do you suggest resolving those?
If I can defer to the sponsors. It's not a question that I've been asked before, and so I would like to defer to the sponsors.
Thank
Sure.
you.
Again, I'm Andy Mudrick. I'm the Deputy Director at Disability Rights California. There actually are not inconsistencies between the Lanterman Act and FEHA. The Lanterman Act provides services and supports to people with developmental disabilities through the regional center system. It does not provide for civil rights protection on the basis of protected categories that are in FEHA, such as race, gender, religion, et cetera. As I understand the opposition, it's about the ability to do things like ask disability-related questions pre-employment, which are prohibited by FEHA. I agree that is a legitimate concern, and we've worked on some language where we're happy to work with the opposition to address that issue. But on the question of Lanterman, there is no inconsistency between what the Lanterman Act provides and what FEHA provides.
So I think we're all, I think we're all wanting to see this happen, just to make sure it doesn't make things worse for anybody and those proverbial unintended consequences. So, and I'd like to also ask you the liability issue. Would you expand a little bit on why you're concerned about liability?
I think the concern is, for example, as was mentioned, FEHA prohibits pre- and post-employment inquiries about disability. This is something that's required of us as part of state regulations and state law. And our contention is we should be able to comply with state law and not violate FEHA at the same time.
Could you respond to that concern as well?
Sure. It's actually pre-employment questions that are prohibited. Post-employment questions can be asked if they're related to a business need and necessary, which I believe they would be in these situations. So I think we're really talking about some limited situation of pre-employment inquiry, again, which we're happy to work on language to address.
And to the author, are those the issues that you're now trying to resolve?
Those are the issues. I just got the language, like I said, about an hour ago, and my concern always is when we're playing around with the definition of employee that we don't have unintended consequences in other employment situations. So we want to make sure to pass that through. I know that law much better than I know the Lanterman Act and how this interferes. So I wanted to look at it and ensure that we're not creating a new definition of employee that somehow undercuts traditional employment law. But I think that we can get there. I think we will get there. But we do want to provide, obviously, folks with disabilities with the same kind of civil rights protections against discrimination based on the protected classes that we expect everybody to be protected against. So.
Very good. Thank you. And so I'll look forward to seeing how it evolves as if the bill does get through committee. With that understanding, it's still got a few tweaks that need to be done. Any questions, Mr. Vice Chair?
Madam Chair, you used the term regional centers a few times. What does that mean?
You want me to? Either way. So,
Of course, through the chair, but you may answer that question.
So the State Department of Developmental Services is responsible for providing services under state law under the Lanterman Act to people with developmental disabilities who qualify for services. To do so, the state contracts with 21 nonprofit corporations called regional centers throughout the state.
And they would be nonprofits like Goodwill Industries?
No, they're actually called regional centers. So there's
The Orange County Regional Center.
correct.
Okay, thank you. Thank you. That's for. So then, what about Goodwill Industries? Would this bill impact them?
So Goodwill Industries, to my knowledge, does operate sheltered workshops. So it would impact them to the extent that it would prohibit them from discriminating against employees who work there on the basis of things like race, sexual harassment, the things that most employees take for granted.
But they would be coming in to find some work or some purpose or activity, so they're looking for something to do, and you're saying they have to be hired first before Goodwill could accommodate what they can do?
No. They're actually, this applies to employment, so people who are workers at Goodwill, if they work in a sheltered workshop, they're under current law, they are excluded from protections. So Goodwill could fire someone for being an African American or a Latino with no state law protection. Goodwill could sexually harass, condone sexual harassment of employees in sheltered workshops with no state law protection. So all that this bill does is remove that exemption from FEHA.
It wouldn't, just if I could, it doesn't prevent them from operating a sheltered workshop. I mean, and I'll be very honest, there are those of us who maybe don't agree with that model of employment, but it in no way interferes with their ability to continue with the service that they currently provide as far as working with folks from the disability community, being able to pay them less than a minimum wage based on a federal waiver. All those provisions would still be available, unfortunately, to Goodwill. What we're talking about is once they're actually in employment, that the actual worker, in whatever circumstance they're in, would be treated the same as far as protections against discrimination based on race, national origin, sexual orientation, everything that the California law provides for every other employee.
Mr. Palmer, could you respond to that for me, please?
I think in terms of whether or not there's a remedy in existing law, we could do some research. You can probably find a remedy for some of these things. But we, to be clear, do not object to applying the protections here to these employees. All we're trying to do is make clear that to the extent they're inconsistent with practices that are necessary and authorized under law or regulation, that we're not liable for FEHA or for violations of FEHA for complying with existing law and necessary practices.
Thank you, Madam Chair.
Well, since there are no other questions, no other members, and hopefully if we could get some of our colleagues on the committee to come on down, if you will, that would be helpful. But in the interim, Assemblymember, would you like to close?
I just, this to me is common sense. We have a group of folks who, I think it was said best, you know, inside of a archaic employment model that are being treated as second-class citizens, quite frankly, from things that we take for granted. And as much as we hope that employers, of course, would not engage in this activity, these workers have the same or should have the same rights under California laws as every other worker once in that situation, employed in that situation. So we're trying to get to the most normalized situation as possible for every Californian, no matter how abled we see them. So I respectfully ask for an aye vote.
Thank you very much. And when we establish a quorum, we'll hopefully have a motion and a vote on that. In the meantime, thank you all for your testimony and appreciate your efforts here today. Thank you. Moving along now to file item 3. I'm sorry, Assembly Member, I believe you also have another item. Excuse me, file item 19.
Thank you. Thank you, Madam Chair. Assembly Bill 2159 will ensure fair and just compensation for every Californian, regardless of immigration status, through our civil justice system. Over the past 20 years, this legislature has granted all Californians the right to obtain driver's license, qualify for in-state tuition, and obtain law and other professional licenses. We also protect immigrants in California's labor laws. However, under Rodriguez v. Klein in 1986, the California Court of Appeals ruled that a plaintiff whose immigration status puts them at risk of deportation is not entitled to future wage loss compensation at their California wages. As a result, future wage loss earning damages are instead calculated in the wage range of their country of origin, regardless of whether they ever plan to return to that country. It has been noted that the ruling in Rodriguez's case has been extended to limit the recovery of future medical care damages as well. This 30-year-old case in California sets a bad precedent since defendants often use it against an undocumented plaintiff as a way to undervalue or defeat their injury claim. It's time to resolve this injustice by preserving the integrity of the recovery process for an individual seeking compensation for the injury. AB 2159 will ensure fair and just compensation for every Californian, regardless of immigration status, and is the right thing to do, and I respectfully ask for an aye vote.
Very much. Witnesses in support.
Good afternoon, Chair and committee members. My name is Jeanette Sanipatin. I am the legislative attorney with MALDEF, the Mexican American Legal Defense and Educational Fund. I'm here as a co-sponsor and here to testify in strong support of this bill. Back in 2014, MALDEF sponsored a bill, AB 560, which prohibited the consideration of immigration status for immigrant children victim of torts. The governor signed that bill into law, and we think that this bill is sort of the next progressive step. As with AB 560, MALDEF strongly believes that the recovery for an injury should not be limited to an individual's immigration status because it sends tortfeasors the wrong message that some lives are worth less than others. California has a long history to prohibit the consideration of immigration status in the Labor Code, the Civil Code, and the Government Code. AB 2159 falls along the continuum of this to ensure that no one should have to face the threat of having their immigration status raised in discovery for the purpose of either intimidating or undervaluing his or her claim for future loss. MALDEF also holds the belief that immigration status is fluid, and it is unjust to impute or attribute immigration status as a means to limit recovery for an injury, whether the limit is placed on future lost earnings or future medical cost. I've practiced immigration law for over 20 years, and immigration law is very complex. Just because someone may be undocumented on the day of discovery does not mean that they'll be undocumented within 6 months or a year or 4 years later. And so it's really unfair to attribute this immigration status because of that. An undocumented injured individual should not have his or her recovery limited because of their status and should not have his or her status debated in court. As mentioned earlier, this sends a wrong message to the intentional or unintentional tortfeasors that some lives are worth less than others. All immigrants contribute greatly to the economic and cultural fabric of the Golden State, and it is unconscionable to allow for some lives to be worth less than others. For the reasons cited above, we urge your support.
Thank you very much. And before we go any further, I think if my counting is correct, we do have enough for a quorum. So, Madam Secretary, let's establish a quorum.
Jackson? Here. Jackson here. Morlock? Morlock here. Anderson? Here. Anderson here. Hertzberg? Leno? Here. Leno here. Monning? Wajkowski?
All right, we do have a quorum present. Next witness. Thank you.
Good afternoon, Madam Chair and members. My name is Noemi Esparza. I'm an attorney at Dreyer Babbage and also a member of CAOC here in support of the bill. And I just want to give you a quick example, one of many that will put the need for the bill into context. We have a client, very representative of many other clients in the past, who sustained significant injuries as a result of a company's negligence, and as a result, he was rendered a quadriplegic. Before this incident, he was a hardworking guy. He's 28 years old, supporting his wife and kids, contributing member of society, paying taxes, of which he would not benefit in the future. And after the incident, he can no longer work. He can no longer support his wife and his kids. And part of his claim is a future income loss claim. You know, he's only 28. Now when the incident occurred, now he's 30. And that income loss claim for any other person would be significant. But for him, under the law, it would be based on the pay rate he would earn for an equivalent job in his home country. So for example, if earning $10 here, maybe $4 for equivalent job over there per day. So that's a significant decrease in his claim, and the risk that he would have to take to make that claim would be the risk of deportation because he'd have to disclose that. So for many folks, the risk far outweighs the benefit, especially since it's being based on currency on a rate that he's not getting paid here. And there would have never been a risk of deportation had it not been for this incident and the possibility of making the claim. And it's just very unfair that now this company, who would have been the responsible entity for compensating him justly, gets a pass because he happened to be undocumented, versus if it was a citizen, they wouldn't get this pass. So we urge your aye vote for those reasons.
Thank you very much. Are there other witnesses in support? If you'd please step forward with your name, affiliation, and your indicated support of the bill.
Gina De Silva with the California Immigrant Policy Center in support.
Thank you.
Joseph Vigil on behalf of CHIRLA, the Coalition for Human Migrant Rights of Los Angeles, in support.
Thank you.
Sarah Lindner on behalf of the National Association of Social Workers, California chapter, in support.
Thank you.
Joe Michael with Equality California in support.
Thank you.
Shane Gussman on behalf of the Teamsters in support.
Thank you very much. Now, we have no opposition that has come forward, but if there is any, if you'd step forward at this time. All right, seeing none, bring it back to the committee. Any questions of members of the committee? I'm sorry, Senator Leno.
Madam Chair, not so much a question, but just a comment. It's been mentioned this is only fair. I think that is the foundation for what you're doing here. And for people to be consistent on this issue of immigration or illegal immigration for that matter, or the lack of decision-making in our U.S. Congress, that one should either take the position everyone who's undocumented should be deported, but if you're not of that belief and you do recognize that, for example, 70% of our agricultural industry is worked by those who are undocumented, that this population is a significant component of our economy. They're paying taxes. And so to treat them the same as everyone else except when something goes wrong is where the fairness comes in. So if you're going to acknowledge they're working, they're paying taxes, they're a part of our economy, well then we've got to be consistent and treat everyone the same. Short of that, if you happen to be of the opinion of deporting 11 million people, that's another opinion. But just for consistency's sake, if not fairness' sake, this is a very wise thing for us to be doing. And I move the bill.
Very good. We have a motion. Any further questions? Ms. Gonzalez, you may close.
I think Senator Leto really said it. It does come down to fairness. You know, these are often folks in our society who, whatever side we're on the immigration debate, we've decided to turn a blind eye to the fact that we have a lot of folks who are working, paying taxes, doing their best, and don't have documentation. They often have U.S.-born children. They often have responsibilities here in the United States, and often have no intention to ever return to their country of origin, most of the time. And so when there is an accident and somebody's at fault, to be able to use their immigration status as a way to unjustly provide them with any compensation is just allowing basically one class of folks who live here who are productive, who, you know, we're talking about future earnings, we know they're working, to suddenly say it's all fine until something goes wrong. And so I know that we're not all on the same page on immigration. We're not all on the same page on what to do about our undocumented population, but our laws should be fair and just, and we have, as a state, decided to protect these folks in a way to normalize their lives every day. And this is just another factor for, in this very tragic case, when we see a paraplegic who basically is told you have to come forward to the court, admit that you're here illegally, face deportation. By the way, we're going to pay you at a rate of future earnings of $4 a day, not $10 an hour. It just is a way to ensure that those who have been injured never get compensation. The same is being now attributed as well to medical care. And we know that if folks stay here, the medical care, of course, will be burdened by taxpayers in the system if they can't receive some sort of compensation from the faulty party or company who has caused the medical situation. So I think this makes sense. It makes sense for taxpayers. It makes sense for our system of fairness and justness, and it makes sense for California and the laws that we previously passed, and I respectfully ask for an aye vote.
I think, too, what the system does now is it victimizes, yet again, the victim. And the notion you had someone who was working hard, doing his best. I suspect there are cases where people don't step forward because they're afraid that by doing so, they're going to be, again, further victimized and deported and separated from their families. It's a system that is just a mess and an embarrassment, and hopefully at some point we can do better. And this, I think, is a good start, at least while we're waiting for Congress to do something. So thank you for the bill. We have a motion. Madam Secretary, please call the roll.
The motion is due pass to the Senate floor. Jackson?
Aye.
Jackson, aye. Morlock? Morlock, no. Anderson? Anderson, no. Hertzberg? Leno?
Aye.
Leno, aye. Monning? Wojciechowski?
It's 2-2. We'll put that bill on call. Thank you very much. Thank you to your witnesses.